Okay, Alex here from The Proper Person. We are here with Wendy from Command the Courtroom. How is it going, Wendy?
Hey there, everybody. It's good to see you. Thanks. I'm doing great, Alex. Thanks for having me.
Awesome. I guess what led this stream was a multitude of questions I was getting on coronavirus. I published a video some time ago, non live stream, just a standard video, and then a few months passed, and now people are starting to wonder I guess what's going to happen in the aftermath of coronavirus and custody orders being violated. That's kind of the main sort of thread that I get is people have been waiting for months to see their kids and they don't know what's going to happen. I thought maybe you'd have some insight. And hey guys, post questions in the live chat because this kind of format where we're live, the best thing is when we get to interact with you guys and not just kind of go back and forth. And also, if anyone notices disparity in volume between Wendy and I, let me know and I'll adjust, try and balance this out during the chat. Anyway, sorry, Wendy, go ahead and go
That's a,
into that.
no, no, that's okay. No problem, Alex. Well, so I'll start off by saying that several states have issued guidelines on parenting time during COVID-19. And I actually created a PDF that I have on commandthecourtroom.com that people can download for free. And it's essentially a summary of the guidelines from a couple of states. These were very early guidelines. I'm an attorney in Arizona, so since I created that sheet, Arizona has now come up with guidelines. The Supreme Court has promulgated guidelines for parenting time during coronavirus. So, the first thing is that if there are parenting time orders in effect, then those should be followed. And I know that COVID is an unusual circumstance, and I've personally had some cases where there were, difficult decisions for parents to make about whether to transport children across major international airports, not one, not two, but three. And decisions were made and the courts made decisions. And what I've gathered from it is this: you got to follow the parenting time plan, regardless of what it says, even if COVID is happening. And if there is some reason why you can't or you don't think that it's safe for your child to be transported, if the other parent's not following social distancing or, quarantining if they need to, then you need to file something with the court. That's really what I've gotten from it, because when people aren't, then they're getting hammered. That's my experience. So follow the parenting time plans, and if there is some reason that you can't, then file a request for a temporary order. If the situation necessitates it, then an emergency temporary order. Does that help,
It helps a
Alex?
lot.
At least.
That's exactly what I always thought. There's a lot of people claiming emergency because there's two sides of this coin. The one side that's deprived of visits, and then the other side claims our child's going to be harmed by the virus. And I always say, well, why does the remedy have to be just violating the court order? Why can't you file some kind of request on shortened time or some kind of emergency something? And even some people are really in a desperate situation, and I'm like, okay, if you're going to violate the order, at least file something so that the court can see, okay, this parent has violated the order, but they filed this emergency whatever, and even though right now they're in non-compliance, this shows that they do want at least my attention on this issue. And I think, coming from the perspective of a non-attorney, I was always trying to make myself look different from all the other non-attorney self-represented people. And one of the things that I think the judges see a lot is just willful violation of a court order. So I would always say,
Yeah.
look different from all those other parents. If you're concerned about them pointing the finger at you and saying you're using coronavirus as an excuse to deprive me of visitation, then one of the greatest ways for you to show that's not true, nip it on the bud, anticipate that attack, and ask permission before you withhold. And
Yep.
it's there's just so many things that you can do to keep yourself out from being painted as the parent who's just abusing coronavirus to get what they want, which is to just frustrate the other parent. And I completely agree with you, and that's one of the things that I've been telling people. I think it's amazing that your Supreme Court has entered, it's like a specific list or guideline. You want to talk more about that? Because I don't think many states have done that, and I know ours hasn't. So
Yeah, yeah. So they are guidelines. They are not technically considered the law. They are only guidelines. And the guidelines are interesting because they do encourage parents to work together especially in the situation where somebody's possibly been exposed. And, the guidelines talk about quarantining, they talk about supervised visits, and how you navigate that. And what I think is really interesting about the Arizona guidelines, and I think they mirror some of the other guidelines, is that they provide that makeup time is a realistic possibility if one parent's been deprived of time because of COVID. But I really, the thing that stands out the most to me, because the guidelines are 2 to 3 pages long, excuse me, and I don't have them up in front of me right now, but what stands out the most is that you got to follow the parenting time orders. And I've been in situations since COVID's been happening. I've been on both sides. And in one of these situations, it happened where my client was states away from the other parent. And there was really questions about whether the child should be returned. And meanwhile, what's happening is courts are shutting down. All of my hearings are canceled. Courts aren't setting hearings in Arizona. And I understand that there were a few courts that were, doing emergencies. But at that point, I think my client thought it was best to try to work it out. And that's really the best thing that a person can do if they can, is try to get with the other parent and work something out in writing. If you don't know this already, if you don't have something in writing, then it's just not going to hold any water. And even if you do have email exchanges, depending on what state you're in, those email exchanges may or may not be considered binding agreements. In Arizona, there's a good argument that they could be. I don't know about Nevada or other states, but always try to put these negotiations in writing, because like Alex, like you were saying, it distinguishes you from the other parents who just, withhold. It shows that you're trying to be reasonable. It shows that you're making a good faith effort.
One of the best
at, yeah, go ahead, at working this out. Go ahead. One of the best
things I'll tell people is if you're going to withhold for a certain amount of time, write in the communication that you're sending them, I'm going to withhold for this time because of coronavirus, and why don't you take this amount of makeup time after the situation's over. It's still not good to violate the order, but anything that you can do to show that your motivation is not to just deprive them of custody or visitation helps. Some judges still might not like that, but at least you can show, hey, I wasn't just trying to take their time, I was just trying to move it to a time in the future. These little things make huge differences. We got a bunch of stuff here, some hellos from Christine and Rosanna and Tenacious Warrior. And Tenacious, if you have any questions, send them to Wendy or I. She's the one that helps with your questions, right?
Yes, she is.
Excellent.
She is. So hi, Christine. Hi, Tenacious. For some reason, my chat's I'm not seeing the people who are on, but hello, everybody. So yes, and what's interesting is, in the case, one of the cases that I had, my client did take the strategy and said, listen, once it's safe for the child to fly, you can have a ton of makeup time, but the judge didn't buy it, and the judge is always the wild card in these situations, because I had other people tell me who were in other or similar situations that they made the argument to the judge that the child should stay put until things get better with the pandemic, and the judge agreed. So, it just depends. Yeah. So I pulled up the guidelines, and I am looking at denial of parenting time, and what Arizona guidelines are saying is that the pandemic is not generally a reason to deny parenting time, but parents should use common sense during this health emergency to protect the safety of their children. Unless otherwise ordered by the court or exhibiting signs of illness, parents are considered fit to care for their children and make decisions regarding day-to-day aspects of parenting time while the children are in their care. So this has come into play, I think, quite a bit, where one parent is saying, yeah, dad is not as careful as I am, or mom is going to parties, and I think really, the court is saying here that parents who have parenting time with their children are entrusted with decision making as it relates to those children on a day-to-day basis. And so if they decide, I guess, that they want to go to the park and they feel like it's safe, then they're going to be able to do that. And the other parent may not necessarily agree. And if that parent does not agree, then their remedy is to go to court.
There's 3 questions here I was going to hit. So one is from Allswell. How do you see a non-custodial parent knowingly and willingly exposing the child to coronavirus affecting their visitation access in the future? And the next 2 are in the same vein. So I'll just read them. My ex was tested positive and the kids got, this is from Rosanna. My ex was tested positive and the kids got it. He is letting me make up the time, but I'm frustrated that he didn't take it seriously. And then all's well.
Oh,
Says, how will a non-custodial parent's unreasonableness to cooperate, co-parent with the other custodial parent affect their visitation access in the future? My short answer is the best interest factors, and Wendy, take it away, I guess, because I don't see how.
oh yeah. I think that pretty much sums it up, Alex. Look at the best interest factors, and that just really goes to how are you treating the children's best interest, right? And if a parent is knowingly and voluntarily and willingly exposing the children, then the court is going to be interested in that. For the parent who's wanting to show that this knowing and willing exposure to COVID happened, I'm interested in knowing how you're going to show that. Are there going to be pictures that you got from Facebook where they're at a pool party? Like, how are you going to demonstrate that? What are your ideas, Alex, for ways that people can show a knowing and willing departure from the safety protocols that have been put in place by the CDC?
That's exactly what I was going to say, is how are you going to prove it? Because the first defense is, I didn't do it on purpose. It was an accident. I didn't, and I didn't take it seriously sounds really bad, but the courts have to weigh so many different factors that a lot of times parents will do something neglectful and the court won't modify because of, all these other situations, all these other best interest factors. And so I feel like the only thing that would maybe work is if somebody said something like, hey, I don't care if my child gets coronavirus, it doesn't matter. And some kind of communication in writing like that might really impact a judge's decision. But even that, I can see them just sort of scolding the parent, something like, you shouldn't, because I've seen it before with medication disputes, and our child should get on this medicine, and other parent disagrees, and the doctor says that this is what's best, and the judge still just kind of scolds the other parent. They won't necessarily modify. I think it's a hard sell.
It is. I agree. And, and there's so many viewpoints on this COVID thing. And I don't know where individual judges sit. I know that I sit kind of on the strict end of this spectrum in terms of, we're not leaving our house, we're getting our groceries delivered, my daughter's not having play dates, and that's just how we are. And we have friends who are in the middle of that, and then we have friends who are the complete opposite, who are going out to eat, they feel comfortable with that, and going to parks and stuff, and you don't know what judge you're in front of. So some judges may be really strict about isolating, and other judges may be non-maskers,
Yeah.
So it really depends. It's the luck of the draw too, I think.
That's definitely, we've talked about discretion a million times, and that's one of the things that frustrates people, is the unpredictableness of whether or not what they're doing is right or wrong. Oh my gosh, I just saw this in the news today. Tell me what you think about this. Apparently a New York Supreme Court, maybe it was an appellate court, held that anti-disparagement orders were unconstitutional, and that parents had a constitutional right to post their stories online, their child custody and divorce actions.
Wow.
It came out today, I think. That just
That is
jumped out at me.
crazy.
We should probably talk about it. Super current.
Yeah, we definitely should talk about that. I did not hear that because I was glued to my computer doing a pretrial statement all day and getting ready for a hearing. But that is, so was it a freedom of speech thing?
Yeah.
Is that,
I feel like we're at a nexus where there's the old days where you didn't want to have this stuff all over the internet, and then there's this new era where now it's not so strange for a child to go through divorce and separation. It's so common that in and of itself might not be enough to sort of protect. I think we may have talked about the Norm Macdonald interview with Judge Judy, where she denounced most of the family court judges and stated that the solution to the problem was cameras in courtrooms, which is a shocking thing for her to say, because I don't know if you know this, but she was a supervising family court judge in Manhattan. She wasn't just a TV judge. And to see that decision, it seems like I don't know about your state, but in Nevada, I feel like I'm going to push it with my role as our administrator of our Nevada judges. I'm already in a guardianship case, and it's going really well, and I want to push that envelope, and I feel like this is going to be a tough sell. I think a lot of attorneys and judges don't like the idea, but I still question their motives as to why. And but the children argument, it's there, but it's just going to be one of those things where there's so much good and bad on both sides. and which one
Yep.
weighs more than the other. And it's tough because
Well, I could see the potential though for, so if there's not these requirements in place, anti-disparagement requirements in place, so then a parent goes hog wild on social media about their ex or soon to be ex, then I think that this really could come back to bite them in the butt.
yeah,
I mean, they're allowed to do it, but then it's showing, I think, their ability to
yep,
co-parent, and
it's,
that hostility in my mind shows an inability to co-parent,
it's
which could affect ultimately custody.
right. It's still gonna sound in the best interest factors, and because there's no way to really know how a judge is gonna rule, it could. No attorney would say do it because a judge could just get upset and find a reason to rule against it. It's gonna be. I don't know. Something's gonna happen with this in the next probably 4 to 8 years. I mean, I don't know what to tell you. There's just this pressure to get more into the public's eye with regards to child custody, but at the same time, it's exactly what you say, is there's malefactors out there who don't really have any interest in actually helping their kids or helping the public understand, and they really just want to inflict damage to their ex, and of course their kid's going to suffer for it. And I guess that's the impossible
Yeah.
situation that people are in. Even with media coverage, I think it would have to be strictly controlled, and let's go through some of these questions.
Yeah.
So we have Melissa Banks says, and I'll try and go through like 4 or 5, and then we can see what we can, because there's a lot. Melissa
Oh,
Banks says
good.
they already gave the father makeup time for our preemie infant who isn't following CDC guidelines or hasn't had any training on his health condition. We just got out of the hospital due to lung failure. It sounds alarming. What about parents that refuse to work anything reasonable out with the other parent trying to make a good fit? That's going to go to failure to communicate to meet the needs of the child. I think the one prior is mental and physical health. So more best interest factor stuff here.
Right.
Melissa Banks, all's well. They had so this is a case where a habeas corpus was issued and granted against the mother, and I guess the police went and seized the child, turned it over to the other parent. And then we'll do
wow.
2 more here. Judge hadn't even heard my side of the story. Makes me wonder if there was even a hearing. And then the last one, I guess, is I didn't know what habeas corpus was until I got something with one served with one the day before the hearing, and I missed the hearing because it was the child's audiology appointment. So anyway, I guess we could talk about enforcement. How popular is that in Arizona, using these writs and sending police to seize children?
Well, I don't see a lot of police seizing children, and I don't see a lot of judges ordering that. I've had it maybe once or twice in my career, and I think that probably a lot of judges are of the mindset that that could potentially be really traumatic for the children, depending on the children's ages. But as far as the enforcement, I mean, enforcement actions happen all the time, and sometimes police get involved, but not in terms of grabbing the child and from one parent and giving the child to another, but sometimes they show up kind of as a civil standby to keep the peace. But enforcement actions, as long as there's an order that's clear, I mean, I feel like those are pretty easy to win.
Yeah.
And I encourage my clients to take care of them, or take advantage of them if the situation demands it. And usually it's not just one thing that happens, and then you're going to win an enforcement action. I feel like with enforcement actions, you need to have kind of more of a pattern. I mean, I'd like to see at least a few instances of whatever the issue is happening before we file the enforcement action, not just one time like dad didn't return the kid, but now I have the kid. You know what I mean?
Yeah.
But when it's part of a bigger suit, like say we're in the middle of a petition to modify decision making and parenting time, and then we throw in enforcement issues, then maybe they are not as serious, or maybe there are not so many infractions as there would be, or that I would want if I were just filing an enforcement action on its own. Does that make sense?
It does, yeah. Here, it seems like it needs to go to the point of the judge making a finding of fact that it's parental abduction under the NRS, Nevada Revised Statutes. And then that triggers all kinds of issues for the abductor. So there's a crime piece of it, but there's also sort of a finding that they can make under our civil code. And then once they make the finding, that parent is disqualified from, I think, anything that's not supervised visits, because it's so traumatizing. And, I feel like the blame, who does it go to? Is it the judge's fault or is it the withholders? That's really the question there.
Yeah.
If it's the fault of the withholder that the police had to physically seize the child, it makes sense. It takes a lot, though. It's not common here. You're right. And then there's situations. There's one case we're covering. We have cameras in this courtroom that is the mom's charged with child abduction and kidnapping. These are criminal charges. And that one's still pending right now. There's another couple of comments here from Melissa Banks on her preemie baby, and I wonder if you have you ever had an uncomfortable sort of discussion with a client? Because I sometimes have these discussions with my viewers that you created a child, but I don't think it sinks into people that the child isn't owned by you like a piece of property, even if you're still together. The state, and it makes people really uncomfortable, because most people, you'll talk to them and they'll say, yeah, my child's not a possession, I don't own them. But then at the same time, when the state intervenes to do certain things, people lose their minds. And I wonder if sometimes there's an uncomfortable discussion there that, the government doesn't let you sort of own those kids. They will do things that they could intervene, and there's laws that really make it difficult for them to do it, but they still can do it. And does that kind of shock parents a little bit when you tell them? I know my viewers don't like it.
Yeah, I mean, I don't know if it shocks them, because I feel like, at least where I am in Arizona, it takes quite a lot for the government to get to that point of intervening. I mean, we were talking about some serious stuff has had to have gone down. I mean, we're talking about serious abuse or neglect or something like that. So, when I share with the potential clients or my viewers, that this is why the government's stepping in, I don't know that it's so much of a shock then. I feel like oftentimes where I find people shocked is if they are like the primary caretaker of a child for many years, and now they're going through a divorce or some sort of custody dispute, and I'm telling them that child does not belong to you. I know that you're the one that's done all the doctor's appointments and gone to all the parent-teacher conferences, and the only person who's gone to the extracurriculars and all of that, and I know that, but the child doesn't belong to you. The child belongs to the other parent, and then they're telling me, well, the other parent as well, and they're telling me the other parent was never involved. In Arizona, the viewpoint is, well, now they want to be involved and they're going to get that opportunity. So I feel like this discussion over the child does not belong to you is more difficult in those situations. It feels less clear to me.
Yeah,
do you see what I'm saying?
I even dedicated a video to it. I call it Deserving Custody, because the court's perspective is exactly what you said. How are we going to make this child's life as best as we possibly can going forward? And they're not necessarily going to look into the past and say, well, since you had the most of the time and the other person didn't, you deserve custody. The situation is, it's nice what you were doing in the past, but if this other parent wants to get involved now and be an active role, isn't that what's better for the child going forward? And I feel like sometimes the primary caregiver gets stuck feeling like, well, it doesn't matter what's in the child's best interest, it matters what I deserve. And since I did, it's a deserving custody issue. I also have a little bit, I touch on it a little bit in custody by morality, but not as much. Here's another side of that coin, that same question. So it's one thing when the government is intervening sort of externally and reaching into your family, but here's another thing that people struggle with is when they're in a child custody or divorce action, they don't, at least my viewers sometimes struggle with the idea that they aren't the only one that has rights to do certain things, and that the government is there making decisions, but they're more so mediating between the two of you, because you both have these rights and they have to figure out sort of how to split them between the two of you. And I have some viewers who are stuck on the idea that no, the government should stay out, and they can't seem to connect the fact that the other parent is really the one that's in there trying to sort of sort this out, and the government's just trying to sort of be like a referee. Is it difficult for you to get that distinction through sometimes?
I feel like I've never had an issue with that. I've never had an issue with that. I guess I'm lucky. I've never had an issue with that. I mean, it is frustrating because at times, like I've been on the side where the government's not necessarily on my
Mhm.
side, but I feel overall though, the government is supposed to have the best interest. Everybody's supposed to have the best interest of the child or children at heart. That's what we're all working towards, is the best interest of the children. And so I always focus on that. And there's, not all government attorneys are alike, but, for the most part, I've always felt like everybody's working in that direction.
Yeah.
And if there's an issue that I'm having with a client or a party, I feel like it's because maybe they're resistant to do some of the things that they're being asked to do in order to become, fit in the eyes of the government. That's where the difficulty has laid for me.
Yeah. So we got a couple. I'm going to go through a few of these. So the first one, Melissa Banks, is just 30 pages from his Facebook, basically supporting non-compliance with CDC guidelines. And then Roxanne says, what if you have text messages of your ex saying... So I feel like here we're hitting evidence. Do you ever... Okay, so almost my immediate knee-jerk reaction is, what are you doing to push for an evidentiary hearing? Because most of the proper person litigants don't know the distinction between an evidentiary hearing or trial and just a run-of-the-mill, let's go talk to the judge type of hearing.
Yeah.
I don't know about you, but sometimes my viewers think that there's evidence is evidence and the judge should consider it no matter what, anytime. And
Yeah.
It's like they get frustrated because they go into court with all this documentation and the judge is like, well, we're not here for that.
Yeah.
They just want to work it out and get the parties to agree in the courtroom. And do you ever have that issue sort of, or do you want to elaborate on the importance of pushing for an evidentiary hearing when you actually have a case, and what is the difference between any other hearing and that? I don't know. Maybe that'll help the viewers a little bit.
Yeah, so we have all kinds of different hearings in Arizona, and so in Arizona, evidentiary hearing and trial are pretty synonymous. Are you presenting evidence? Well, then it's an evidentiary hearing or a trial. You can call it what you want. There are other types of hearings that are, status conferences or resolution conferences. And, the key, I think, is to look at the court's order where the court is setting that particular hearing to determine whether evidence is going to be presented, whether witnesses are going to testify, whether you have to submit a pretrial statement or exhibits in advance. And if you have to, then that's a clue that it's an evidentiary hearing, and hopefully you've disclosed your evidence and gotten your ducks in a row. And so these days, like, I judges who are pushing us to settle right on the eve of trial, like maybe in the month or two before, and we go in for a pretrial conference and they're saying, consider mediation. And sometimes my clients do and sometimes they don't, and it really, it just depends on how set they are in their position and what they feel is right. I mean, and it's always a balance, Alex, because here in Arizona, judges will hammer for people with attorneys' fees and costs if they feel like that person is not being reasonable in their positions. Even if they want to protect their rights and make a record and all of that, they will get hammered. I just had one client who got hammered big time, and I didn't think he was being unreasonable at all, but the judge did. And so the judge made that order. But I feel like, if you're really committed to your position, then you have to proceed to trial.
Yeah.
You have to, otherwise it's going to be years potentially before you can turn it around. There's going to have to be a significant change in circumstances before you can go back to court again. So this is your chance. If you feel like you have all of the evidence and, you have your witnesses ready to go, then maybe you should put it out there. Although, I do recommend mediation. There are many cases where mediation helps the parties work things out.
We got a few compliments. Thank you guys for those compliments. There's some questions at the bottom. Before I hit those questions, I was going to ask you sort of a fun question. Are you still venturing into appeals a little bit?
Well, you know what? I had chatted with you a couple months ago about potentially venturing into appeals, and we ultimately decided not to. But it's something that I'm interested in doing. It's something, frankly, that's a little bit scary for me.
Scary, but you get a rush. I mean, it's really the next level. And like I said, I lost so many before I started to win them. But I feel like before winning appeals, you just don't know who's right and who's wrong, and it just feels like every single courtroom is just completely different. And
That's true.
It'll be fun to get the outcome of one of them. Eventually, you'll get to do one, I think, but they're tough.
I think so.
Yeah.
I'm sure I'll be calling you for advice too.
They're just my favorite thing ever, and I like how there's so much emotion in family court in the courtroom, and there's so little emotion in an appeal. And I love how there's hardly ever a hearing. I don't think it's the same in Arizona though. So let's see. Here we have. Allswell says, Melissa, I'm sorry you're experiencing. So this is again the preemie baby. Dean Crossman says, hey Alex, what are your thoughts on one parent putting a child into volunteer at a summer camp without input from the other parent? How do you think it'll go over when presented to the judge? So I have a video on extracurriculars, Dean, if you get a chance, take a look at it. But this is definitely Wendy's, I think, going to have a lot of insight on this. But my perspective on extracurriculars is it's incredibly complicated if it's a high conflict child custody case, because a high conflict child custody parent will try to use the extracurriculars to create more exchanges and more contact. And so their motives are impure. And it's with a high conflict parent, they're trying to find a way to make you look bad if you object to the extracurricular. And then if you agree, then when you have exchanges, they're going to inject conflict into those additional exchanges. With a low conflict parent, extracurriculars are great. You guys can get those kids doing all kinds of extra things, whether it's a sport or a musical instrument, whatever it is, it's always great. It's so tricky when you have a high conflict case. Let me know what you think about this, Wendy, because some judges don't like it when you don't do it. When one parent's like, no, and then the other parent makes them look bad. Hey, they don't want our kid to get into chess club or something. And then some judges understand because they've seen the crazy. So
Yep. Yeah. It is difficult. And I agree with you. I mean, with every new topic in a high conflict relationship, extracurriculars or, a new school, it just opens up a can of worms. And the more defined that you can get things from the get-go, the better. So, a lot of times in the high conflict cases where, the kids are already participating in extracurricular activities, then we put provisions in there that, these are the ones that they're in, and that's the way it's going to stay. And maybe that's not best for the kids, but it kind of helps put some boundaries around that parent who might be inclined to create more conflict. But it is difficult. And even for the parent who is not the high conflict parent, I think it's important, even if they know that this conflict is never going to be resolved, I still believe that it's important for them to engage in the conversation with the high conflict parent where they know it's never going to be resolved, because I've had situations before where this conversation wasn't happening because of the high conflict nature of the relationship. And I've had judges say, well, parent, you weren't engaging, you weren't conversing, so guess what? I'm giving custody to the other person.
That's exactly true. Because even if so my viewers have the same problem where they'll say, well, I'm not going to reply because I know what they're going to say. Okay, well, it's nice that you know what they're going to say, but the judge doesn't. So you sometimes have to go through the formality just to get that response in writing, so that if it goes to court, you can say, look, I tried, and here was the response. There's a great comment, I guess you could say here, from Allswell. I love this topic. It's so weird how CPS and police won't step in for us, but when the NPD does, they're all for it. I'm not sure we need to go into the comparison as to why they may intervene for one complaint and not another. But what I do want to talk about is, I don't know how big of an issue this is for Arizona, but in Nevada, CPS and the police apply different laws to what's going on with the child. CPS here has a completely different statutory scheme that has to do with abuse and neglect, and the standards are not necessarily the same as best interest of the child. And my opinion has always been that you, as the mom or the dad, have a lot of power with the best interest factors, a lot more latitude, an easier standard of proof. They don't get a free attorney. And to me, I think people struggle. They see CPS as a sort of extension of their custody case. They don't see it as a separate proceeding with different rules, different standards. They don't have any litigation power. These are technical things that I know, but my viewers struggle with this a lot. What do you think about involving CPS and police? It
I try
backfires
to
a
avoid
lot
it.
here. Go ahead.
That's what I think. I try to avoid it. I try to discourage against it. In CPS, here it's called the Department of Child Safety.
Hmm.
It used to be CPS, but it's now DCS. And I feel like that is an animal, it's a whole different
Yeah.
animal. And they have policies and procedures that are foreign to me. I don't feel like they are applied consistently. I feel like the caseworkers are probably overwhelmed and underpaid. They maybe are not trained as good as they could be. So I feel like anytime you get CPS or DCS involved, it's a crapshoot.
Yeah.
I mean, these cases are risky anyway, but even with DCS, they can remove your children and put your children in foster care
Hmm.
and like that. I mean, from one day to the next.
Yeah.
And anytime, I just discourage against that. And if there are issues, then let's go file in family court, unless
Yes.
it's an absolute clear-cut case.
Yeah.
And so I try to discourage against making calls to DCS and the police. If there are issues, unless somebody's bleeding or dying, then let's go to court and get some sort of emergency order.
I strongly
That's
agree.
my thought.
You have all the control there, and
Yeah.
we talked about all the differences, and there's been cases with my viewers where CPS was called and actually turned into a witness in the child custody case for the other side.
Hmm.
And then
Yep.
there's some states out there, Wendy, that are really weird, where they don't like. There's in Indiana, it's called CHIPS, and
Oh.
they have CHIPS proceedings, and they don't get involved unless both parents are incapable of protecting the child. So they'll have
Ah.
like a dad or a mom will call, and they'll say, well, we can't get involved unless you say you're unable to protect this child. And then once that parent signs that particular document, it's exactly what you said. They take the child. And that parent's like,
Mhm.
hold on a second, I didn't do anything wrong. And they're like, well, you said you couldn't protect your own kid. That's happened because it's like
Yep.
CPS is there when that kid needs protection. I mean, if you can't do it, they will, but be careful what you're asking for. You might get what you wish for.
Uh,
And then
Totally.
good luck trying to fix it because, as you said, it's very difficult. So, let's see here. Next question. We have Rosanna saying she's not been in court since 2018, and so much has happened in her case. She doesn't want to go back, but her ex admitted on the stand in a protective order dispute. So I'm not sure what you're saying there. I'm going to go into the next question here. Dad withholds information from the child about what trouble she's in, saying he won't discuss her crime and punishment until changing over to his care. So this is mainly lack of communication or failure to communicate to meet the needs. Really bad parenting time. Let's see here. So statements of admission. Some comments here like there's statements in writing, sorry about abusing the child or something like that. Sometimes those things aren't clear cut, guys. I mean, I doubt they used the word abuse. They may have said something like, sorry, I didn't do the right thing. The court here, at least, isn't necessarily jumping at the bit to say, you said you did something wrong, I'm going to punish you. Sometimes the judge will say, well, it's nice that they told you that they made that mistake. That's an opportunity for you both to learn
Right.
from and move forward. Sometimes, I don't know about your clients, but sometimes it seems like my viewers are stuck in punishment mode and revenge mode, and it's of course understandable. When you split up, that's a normal emotion to have, but the judges don't see it that way, at least not here. They, especially with contempt, if they even get a whiff of you using contempt to punish your ex, they seem to bend over backwards to find a way to deny it. It seems like the only way that it works here is when you go to court and you show the judge, this is your absolute last resort. Everything else you tried didn't work. And this is the only thing
Right.
left. I don't know if you want to elaborate
Right.
a little bit on that.
Well, yeah, this has come up in a recent case for me where I feel that the other party is taking these various actions to strong arm my client to consent or submit to his request regarding custody and parenting time. So he has filed a contempt action in the middle of a petition to modify custody and parenting time, filed a contempt action related to child support. He has filed criminal charges against my client or initiated them with various departments, 2 different sets. So, I feel like, and I don't know if the judge is going to see it this way. I sure hope the judge sees it this way. But I feel like this is really an attempt to pressure and coerce my client. And I forgot what the question was,
No, you
Alex.
did
I don't
great.
even know.
You were right within the boundaries of the question. You were talking about that's totally on point. Yeah,
Yeah.
it's using contempt as a weapon, or trying to focus not necessarily on constructively moving forward to help the child, but to try and find or exploit mistakes here and there, just to inflict damage on the other parent. And that sounds like in your case exactly what you were going through. Christine started
Yeah.
laughing when we talked about appeals. Christine Toasty. Roseanne and Reese have two similar questions on mediation. Rosanna says, can you mediate without court? I just don't want to go back to court. And Reese Weaver says, how does a judge view it if one doesn't go to court-ordered mediation? My answer is quick there. It's contempt of court in Nevada. You'll be punished. Rosanna, yeah, you can go to court without mediation. You know, this is funny because I get this question. People talk about agreeing outside of court, and it's like there's a wonderful tool available to you. It's called a stipulation. I tell my viewers all the time, whatever you put down in that email, just put a couple of signature lines on it, add it is so ordered, and submit it as a stipulation. Do you have clients that are completely shocked at how quickly you can get a court order, how quickly and how cheaply when both sides agree, and how low stress it is?
It's so amazing. I mean, it's so amazing. You don't always have to file a lawsuit, you know, if it's one child emancipates and you want to lower child support, you know, if you guys can agree, yeah, then a stipulation is so easy. It's awesome.
Yeah,
It's really
that's
awesome.
one of the things they
So,
wonder over. It's like, do I have to go to court? No. It's usually done in the mail here. What about you?
yeah, so essentially everybody signs off and we send it with the runner down to court and the judge signs it and that's it.
Perfect.
And the story can be done in a
That's
week.
not,
So easy.
yeah, it's,
So, you know,
go ahead.
you referred to, you know, you just spoke of something and, you know, I'm kind of interested in how you would react or what your thoughts are. So you said, you know, add a couple signature lines and have both parties sign off. So I have a situation where parties went to mediation. They were ordered to go to mediation by the court. They went to mediation. They reached full agreements with the help of a professional mediator. They initialed each page. They put their names on the signature lines, and one of the parties had an attorney. For whatever reason, the attorney failed to file the mediation agreements with the court.
Mm-hmm.
And now that person who had the attorney who didn't file them is now saying, oh, no agreements. We should just go, you know, I was abiding by the court order before those agreements.
Oh, you know what?
So interesting.
I think that I've seen that before, and you can deem them with something called equitable estoppel. So the trick behind, there's two ways to do it. The equitable estoppel way works when there's deception involved. So everybody signs it, and then the attorney that was supposed to submit it never does. And then if the other side thinks that it was signed and it was effective, then the court will ram it through with equitable estoppel. There's another way that they've done it too, and I think it's like promissory something. I don't know really how that one works. Definitely there's two legal doctrines, or at least there's one for sure, Wendy, that I've read about it. That has happened here before, for sure.
Okay.
And there's like 3 or 4 elements to the estoppel, and if you satisfy all 4, and I know for sure one of them is that the other side was misled into believing that something, you know, legitimately was going on, and then there's like deception and exploitation, trickery, stuff like that. So yeah, I know for sure there's something there. And then of course, I don't know if you know this, but once you use a legal principle, if that's one of the things I love about legal principles is when you assert those and they don't go your way, those are much easier to get overturned on appeal. Much easier,
really?
Yes, because you get de novo review on questions of law. So I always tell people, I mean, it seems like it's technical and legalese and it might annoy the judge, but if there's an error on a legal issue, they'll apply de novo review. The judge won't get any deference at all, and they'll overturn it if he's wrong. So there's a few tricks out there that you can use. That I hope you find the answer to that and let me know, because
yeah, I will. I'll see what I can find out. Well, I know in Arizona, when two parties put an agreement in writing and they sign it, it's considered a binding agreement.
Yeah, it should be.
But the complicating factor is this agreement was from a different state, not from Arizona, but I still feel like it's a binding agreement now that we're in Arizona. That's my thought, but
well, it should be.
We'll see.
I know that judges here, when it happened in the courtroom, you can't change your mind. They're like, well, you already said it. It's stipulated on the record. I don't see why that wouldn't work. And yeah, I mean, you should be able to. Yeah, let me know how that one goes. That one's definitely interesting. What happened here was a guy married his wife, then they got the marriage certificate all signed, and then the guy took it and said he was going to mail it in, and he never did. And then when later on the wife tried to divorce him, he said, haha, I never submitted this marriage thing. We are not married and I get to keep everything. And they used equitable estoppel here. So anyway, I'm going to continue on.
Interesting.
Yeah, these things
Interesting.
are cool. Another one I like is judicial estoppel of inconsistent positions. I wish I knew about that one. Oh my God, in my case it came up like 3 times. So that one's used, there's like 3 or 4 elements, and that one's used when your opponent asserts an argument and they win. And then later on in the case, they try and assert the opposite. And it happened in my case. It happened in my case for the first year. My ex's attorney said, I have a right to know, or my client has a right to know where you live. And then when I started to file that lawsuit against the Secretary of State and it went to the Supreme Court, her attorney started to change her argument and said, neither parent has a right to know where their child lives. She literally, that's just the craziest idea ever, but it's like, I didn't know about that estoppel, so I didn't assert it. And had I asserted it, I could have taken it to the appellate court and won. This stuff is so technical, it probably seems so unfair to people because it's so academic. And it's like, wait a minute, these are our lives and our kids, and why is this so academic? And it's frustrating for people.
Exactly. It is. It can be frustrating for sure. Those are good tips, though. Yeah. I didn't know those tips. That's awesome.
Once you learn how to get stuff reversed, you start to look for all the ways you can do it, because it's like the only way you can control these outcomes. It just feels like you're at the mercy of the judge otherwise. It gives you a little semblance of some kind of control. So Melissa Banks, go ahead.
I feel amazed that you feel some semblance of control.
Well, you can't control everything, but there are some things that you can control, and of course, once I find out what they are, I learn about them because it's yeah. So I guess we'll just do another 5 minutes and wrap up. Melissa Banks says, the only thing keeping me going is my son. I never fought for something and someone as hard as I have for him. In my first baby, which she calls her rainbow baby. He has 10 kids. This is my first, and let me raise him in peace. There's definitely something going on there. 10-to-1 ratio. Jules Verne says CPS here will not investigate for malicious reporting on me, even though it's blatantly obvious what his agenda is. These are the CPS comments. We got another one here from Melissa Banks. It says that before we go to court, we have to go to mediation. Okay, so I have something to say about this. I mean, it's kind of technical, but in Nevada, we had a judge try this and he was overturned. So there's local rules that mandate 1 mediation, and those apparently are okay. But a judge apparently in Nevada cannot enter a blanket order requiring you to go to mediation above and beyond that particular local rule, because they're saying here in Nevada that the judge is in violation of his constitutional obligation to sit and preside over cases.
Interesting.
And I don't know if you've had anything like that. I mean, this is a technical thing. Comment. We may end up moving on really quickly. I don't know if you have anything to say on that one.
Well, I mean, there used to be a rule of family law procedure in Arizona that said prior to filing litigation, let me back up for a minute. So people used to put in their agreements, prior to filing litigation, we have to go to mediation, and if one party doesn't do this, then the case can be dismissed, blah, blah, blah. That was a common boilerplate thing in agreement. So, I got agreements dismissed because somebody didn't go to mediation before filing. Well, now there is a newer rule within the last couple of years in the rules of family law procedure that says they don't have to go to mediation before filing. So it like undid all of those boilerplate provisions and all of those. So, it's interesting. I'm not sure why that was inserted in there, maybe for the reason that you were just talking about.
Yeah, they don't often tell us. For example, for parenting coordinators, there were some rules in place, and then the Supreme Court of Nevada said that they were severely restricted when they could be used. And then all of a sudden the local rules changed to reflect that, but they don't tell you that. So you'll see you'll see codifications and rules and statutes change with no explanation as to why, but some kind of appeal triggered all of it. So I understand judges wanting to push settlement. I get it, but some of these cases don't settle, and I don't know if they realize how scary they come off to people when they say you need to settle this case. Even the lawyers get nervous about proceeding. I have. It's nerve-wracking because you're like, this is not a person who is thinking constructively. This is a person who is approaching this custody dispute in a completely antisocial, toxic way. And this now, if I want to go and litigate, now I might get punished.
There was a judge, I'm thinking of a judge that I had to appear in front of for many years, who every case before the hearing, he'd say, counsel, I want to see you in the chambers. And then he'd take us back there and essentially strong arm whoever he didn't think was in the right.
Mm-hmm.
You know what I mean?
Mm-hmm.
And he'd say, you better settle this. I want you to go out there and talk to the other side and settle this. And if we didn't settle it, whoever was not in the right would usually get punished.
Right, that's so messed up. I've
Yeah.
actually, I wish that they wouldn't do these sidebars and these chambers discussions, because the optics it really upsets a lot of people. I would say more than half of the viewers, at least on my channel, get very suspicious because they're in there, they're paying all this money for their attorney, and they're not hearing some discussions, and it makes them very suspicious. And I've talked to some attorneys, and they say the opposite. They're like, our client should just trust us. They pay us money to win their case. Just trust us. We're going to do the right thing. Well, there's
Yeah.
not a lot of trust right now in the family law industry, guys. You kind of have to earn it. It's going to take a long time because it's gone.
Yep.
It's gone to the point where
Yeah.
there's a lot of distrust and dissatisfaction. I don't think I've talked to a single person who said, I loved my experience in family court and my lawyer was amazing. There are maybe a tiny few out there, but I've never heard one approach me or anything like that. It's mainly suspicion and doubt, and yeah, that just doesn't
Yep.
help. It just fosters the suspicion. So I mean, I
I
feel like that was
agree.
5 minutes.
Yeah.
It was really good
Yeah.
having you on, and I hope that
Thank you. That was great, Alex. I really
thought so
appreciate it.
too. Great discussion.
Oh, yeah, it was wonderful. Shay, hello. We're ending, Shay, right now.
Yeah, if you see any of these
So,
comments and you want to jump out, you can. Or if you have any questions for me, I know I kind of led it, but I guess it's on this.
no, that's totally cool. This is your live stream. It's awesome. No, you guys, yep, go back and watch it again and give it a thumbs up if you haven't already.
Yeah.
And I'll have Alex on my channel next time
Okay.
soon.
I'm gonna sign off, guys, and I'm gonna teach Wendy how to double stream to both Facebook and YouTube. Hopefully, you'll see her doing that in the future, and I'll see you guys next time.
Bye, guys.
Bye.
Good night.
Okay, so the stream is ended, and I'll screen share and show you how to do this.